Good morning. Welcome to today's meeting on the Assembly Committee of Government Affairs for the 2025 legislative session. Will the Secretary please call the roll?
Assembly members Carter.
Present.
DeLong.
Present.
De Silva.
Here.
Edgeworth. Present. Flanagan.
Here.
Gallant.
Here.
Goulding.
Here.
Gurr.
Here.
Hunt.
Here.
Jackson. Karras. Kasama. Kasama Wynn.
Here.
Chair Considine.
And I am here. Please record Assembly Member Jackson as present when they arrive. Welcome to the audience here in Carson City. If there's anyone hiding in Las Vegas and anyone on the internet, I would like to begin with some housekeeping measures. Please check and silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide your card to our committee secretary. When testifying, please turn on the microphone and clearly state your name and any affiliation for the record. If you're providing handouts, please ensure that hard copies are available for members of the public. And as always, we expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. And community members will be using their laptops to view handouts and other documents. Please do not interpret this as a sign of disrespect or inattention. Today, we will hear two bills. We will begin with Senate Bill 39, which revises provisions relating to emergency management, and then we will hear Senate Bill 160, which revises provisions relating to the Nevada Equal Rights Commission. After that, we will conduct a work session to take action on measures that the committee has heard. And with that, let's get started. I will now open the hearing on Senate Bill 39. To present this measure, we have Brett Compton, Administrator of Nevada's Division of Emergency Management and Homeland Security. Please go ahead when you're ready.
Good morning, committee. My name is Brett Compton, Administrator at the Nevada Division of Emergency Management. Thank you for giving me time to discuss Senate Bill 39 with you. Enacted on January 2021, the Safeguarding Tomorrow Through Ongoing Risk Mitigation Storm Act authorized the Federal Emergency Management Agency, FEMA, to establish hazard mitigation revolving loan funds, providing grant seed funds for hazard mitigation projects. This program offers capitalization grants to state agencies responsible for emergency management, enabling them to create revolving loan funds for mitigation projects and activities to increase resilience and mitigate the impacts of events such as drought, extreme heat, severe storms, wildfires, floods, and earthquakes. To apply, eligible entities such as the state of Nevada must establish a revolving loan fund to be administered by the agency responsible for emergency management as directed in 42 U.S. Code 5135. To this end, Senate Bill 39 proposes to establish the Hazard Mitigation Revolving Loan Fund. Disasters encompass four phases: mitigation, preparedness, response, and recovery. Hazard mitigation involves reducing or eliminating long-term risks to life and property from hazardous events, serving as a core function of emergency management. This bill establishes the authority to apply for and manage a revolving loan fund dedicated to mitigation activities. It outlines the parameters of Storm Act funding and ensures that the revolving loan funds remain protected from reallocation, aligning with the intent of the FEMA grant. Loan recipients must have an approved hazard mitigation plan. These low-interest loans will enable all Nevada jurisdictions, local and tribal, to decrease vulnerability to natural disasters, enhance community resilience, and alleviate disaster-related hardships. The Safeguarding Tomorrow Revolving Loan Fund offers more flexible requirements compared to traditional FEMA grant programs, simplifying the process for partners to undertake mitigation projects and bolster resilience. Furthermore, these low-interest loans can be utilized as non-federal matches for other significant mitigation grant projects, which typically require a 25% cost share. Initial application for FEMA seed money based on the volume and size of initial mitigation project applications will determine the initial starting amount placed in the revolving loan fund account and will require a 10% state match. The exact dollar amount of the 10% match cannot be forecasted at this time and will be submitted via work program. I'm open to your questions.
Thank you so much for that presentation. Before we get started on the questions, I just want to sort of make a statement and just confirm it with you, because we've heard several bills that when they were created, they don't necessarily conflict, but as those bills pass, they will change other bills. So the reason that I'm asking is because this committee passed AB 553, which was a bill to move emergency management from under the Office of the Military to under the Office of the Governor. And that bill has not been signed by the governor. But I just want to point out to the committee that it might be a little confusion because this bill still says emergency management under the Office of the Military. So just want to make clear, if I've messed any of that, or you want to clarify it, please do.
No, ma'am, that sounds right. When we initially obviously submitted, we are still members of the Office of Military until that bill is passed and enacted. 553 is.
Thank you. And our next question is from Assemblymember Goulding.
Thank you, Chair. I'm wondering if you can provide some examples for us and also describe the flow of funds. So the department or the division applies for the funds, puts it in this loan fund, and then local governments or state agencies can take a loan out from it. Is that correct?
Sort of. Brett Thompson for the record. So the way this works is for our very initial set, we will put out a notice of funding opportunity. So we would solicit for applications from locals. This would happen in the fall of 2026 would be the first time we do this. Based on the number of applicants that we get in that very first tranche, we, the state, would then have to provide 10%. But it basically becomes seed fund for the rest of the life of that, the loan. And so really this is a venue for us to allow them to apply for funds, us to go to FEMA and ask for the 90% seed funds, and then that continues to feed this program as it continues on for perpetuity. It's really an awesome opportunity for the state to acquire funds through a federal program to build a long-term opportunity to assist really with a 25% match for future mitigation programs, because every mitigation grant that you go through FEMA requires a 25% match. And this is really designed to assist with those low-cost loans to help pay for that 25% match. So say if you were a rural county, you didn't have a large budget, but you really needed to do a mitigation program like put a culvert in or divert floodwaters around a particular facility or something of that nature, earthquake-proof a building, you may not have that 25% cash to put up front, but you could do it through this loan program. Does that make sense?
Thank you for that information.
Assemblymember, did you have a clarifying follow-up?
I guess I'm confused. So is what you just said that you can use this federal money as the state's portion of a required state match on a different federal grant? That's what I think you just said, but is that correct?
Brett Thompson for the record, you can use this money for the state's portion or a jurisdiction's portion of another federal grant.
Thank you. Our next question is from Assemblymember Gurr.
Thank you, Chair. I think it cleared it up. I was concerned that it was money that would be loaned to private individuals or private companies to mitigate circumstances, but I think it cleared up. Thank you.
So there was no question, just to be clear. Okay, thank you. Thank you. Our next question is from Assemblymember DeLong.
Thank you, Chair. Thank you for the presentation. I just want to confirm, can you list out the full scope of entities that could apply for these loans?
It's Brett Thompson for the record. It could be a state, it could be a local, or it could be a tribal jurisdiction, it could be a city, it could be any political or any governmental entity within the state of Nevada.
Follow-up, Chair. Could an irrigation district apply for it?
Yes, sir.
Okay, thank you.
Thank you. Our next question is from Assemblymember Kasama.
Thank you, and thank you for your presentation here. I think I've gotten it with the other questions too, but again, just to clarify in my mind. So typically right now, if we're having hazard mitigation or emergency acts that need to be done, currently we get 75% from FEMA as a grant if the state matches 25%. Is that correct?
Brett Thompson for the record, that is correct.
And so this is a new program with the federal under the Storm Act, so that now it is a loan with 90% from FEMA and 10% state match.
That's correct. This program would help the jurisdiction cover the 25% match that you just initially referred to.
Perfect. Thank you.
Committee members, do we have any other questions? Assemblymember Flanagan.
Thank you, Madam Chair, and good morning. Thank you for the presentation. Just so I understand, you said that we would be looking at launching in November. So you apply to start it up from FEMA in November as well? And I ask because the Storm Act funding is through the end of, are you saying November of this year or November of 2026?
Brett Thompson for the record. So we would hire our first employee in approximately November of 2025.
Okay.
We would have to establish the program. We would then have to do the competition, which would occur in really fall of the calendar year 2026. And our first federal application for this funds would be in the spring of 2027. Now, what happened this last year in 2024, the opening period to apply for these with FEMA was from February until April of 2024. This year in 2025, due to changes that are occurring at FEMA, that competition has not yet been released, and we are in the end of May. So I can't tell you the exact timing for 2027, but based on 2024s, we would anticipate that to be in the spring of 2027 when we would compete with FEMA and receive our first allocation.
Madam Chair, may I have a follow-up? Go ahead. So help me understand, because the Storm Act dollars were designated through the end of 2026. So has some adjustment been made at the federal level of how long this funding would be available for us to attempt to get the fund set up?
No, ma'am. At this point, the initial allocation of storm funds expires in 2026. Our ability to continue with this program is contingent upon FEMA or whatever version of FEMA comes in the future renews this program.
So you're expecting for the program to renew, and that's the expectation, that you're hoping that it will still be there past the current deadlines?
Yes, ma'am. Hope's not a method, but in this case, we are hoping. However, if we do not have the program in place, we can't even attempt to do this in the future.
Correct, I understand. I just wanted to make sure you have the timelines
Yes, ma'am.
expecting to be able to be successful given the 2026 ending of the Storm Act.
Yes, ma'am.
Thank you.
Thank you. Would you be needing any additional staff to fill out or apply for these grants, or does current staffing allow for this?
Ma'am, Brett Thompson for the record. So in the money committees in the budget that I was approved, it provided for a temporary employee for the next biennium to set this program up contingent upon the passing of this bill. And that would be sufficient. If the program continues and is approved, I would reapproach to convert in the next biennium that temporary person to a full-time.
Thank you. Committee members, do we have any other questions? All right, seeing none, thank you so much for your presentation. We will now move on to testimony. Testimony can be provided here in person in Carson City, by video conference in Las Vegas, or over the phone, and further instructions on providing testimony can be found on the agenda. And we will begin with testimony in support of SB 39 here in Carson City. Seeing no one approach for support testimony for SB 39, we will move to Las Vegas. I'm seeing no one in Las Vegas, so AVH, is there anyone on the line in support of SB 39?
To testify in support of Senate Bill 39, please press star 9 to take your place in the queue. Again, press star 9. Chair, we have no callers for support at this time.
Thank you. We will then move to testimony in opposition. Is there anyone here in Carson City wishing to testify in opposition to Senate Bill 39? Seeing no one approach and no one in Las Vegas, AVH, we're back to you for testimony in opposition to Senate Bill 39.
To testify in opposition of Senate Bill 39, please press star 9 to take your place in the queue. We have no callers wishing to testify in opposition.
Thank you. And then we will check if there's anyone here in Carson City wishing to testify in neutral on SB 39. Seeing no one approach and still seeing no one in Las Vegas, AVH, we're back to you for testimony in neutral on Senate Bill 39.
If you would like to testify in neutral for Senate Bill 39, please press star 9 to take your place in the queue. Chair, we have no callers for neutral.
Okay, thank you. And we would like to invite the presenter back up to make any final remarks. Final remarks have been waived. I will now close the hearing on Senate Bill 39, and we will go into a momentary recess. Thank you. We are now back from our recess. And I would like to open the hearing on Senate Bill 160, which revises provisions relating to the Nevada Equal Rights Commission. To present this measure, we have Senator Dina Neal. Please go ahead when you are ready.
Thank you. Good morning, Assembly Committee of Government Affairs. I'm here to present SB 160. It made its way over here from Finance. So generally, this policy is a shift from Dieter to placing the Nevada Equal Rights Commission under A.G. Ford. Well, it's not even A.G. Ford. Let me not say that. It's under the AG's office. There's opposition to this bill because it would be placed under A.G. Ford. My public policy concern with bringing SB 160 is that since I've been elected, in 2011, I've been on the journey of trying to strengthen the Nevada Equal Rights Commission for various reasons. Because I always have constituents who come and who are saying that, you know, they need to be able to move forward in their responses and feel secure that when a civil rights violation is enacted, that there is actually going to be work. So I have done the Crown Act through the Nevada Equal Rights Commission. I have made sure that if an employer places a false information in your employee file, that you then have the rights to be a whistleblower and then act on that activity. I have consistently tried to bring measures in order to not only advance the 1964 Civil Rights Act, but expand it in the state of Nevada. And so SB 160 is my final attempt to try to do exactly that, which is to strengthen it. When I first considered in the summer what I was going to do, at first I was looking at Boyd Law, right? I was saying if I could get this under INCHE, and then Boyd Law would then be the administrator and then be the creator of making sure that these laws were being administered. That was my first stop, and then I found out it violated the Constitution because we're technically two separate branches, and we wouldn't be able to just roll it on and strip from the governor and then place it with the AG. So then I asked, well, what would the possibility be if I was able to just place it under the AG's office, being that the DAGs already consult with the administrator. They already review the claims that come through the door. And so when I looked at the fiscal impact, it literally made it even simpler because the ability to just pick up the revenue, which is the budget account, and then place it into the AG account was simple. The way that the Nevada Equal Rights Commission works, so when a complaint goes through, there's a portion that's paid from EEOC. So roughly it's about $800 per EEOC case that's closed. On top of that, we have a general fund of about $2 million that goes to that agency in order to run statewide complaints and staff. And so when I looked at the fiscal aspects and looked at the strength that could be gained by shifting it under the AG, I then proposed this particular piece of legislation for SB 160. The language, all of the blue language in the bill, when you see Chapter 228, that's basically the AG chapter. When you see Chapter 613, that is the existing language that currently is under NERC. So there is no new language in this particular bill. And the other side, there were a lot of questions on, I didn't know that NERC was over housing. Well, NERC was always associated with housing under Chapter NRS 118. The difference was that it wasn't expanded. And I had a bill in 21 that tried to expand those housing rights because HUD wanted, we were behind in terms of our statutory provisions under 118. We were still wrapped into some version of 1990, and we hadn't even adopted law and practices that had came from 2008. And so I brought the bill in order to make sure that how the NERC could enter into an MOU with the HUD and then expand the rights and then also get training and make sure that we could expand the Nevada Equal Rights Commission in order to continue to do expanded rights under housing discrimination. So what you currently see in statute under 118, and it references some CFRs, some USCs, is basically what we currently have in law. It is not an expansion because that bill did not pass. That is not new language. That is not anything that popped out of the sky, and therefore I manifested housing rights under NERC. What has been deleted is Section 20, which was new language. And I took that out on the other side when the business community came and said, well, that's actually new language, and it was deleted. And so with that, I will open myself up for questions related to SB 160 in regards to the current law that we are under and how we are practicing protecting civil rights in the state of Nevada.
Thank you for the presentation. Committee members, do we have any questions? Not, Assemblymember Gallant.
Thank you, Chair. Good morning. I thought it was an interesting statement that there's some people that are may not agree with this because Aaron Ford is the AG. So I'm curious, because I do think civil rights is important, particularly in housing. How would you feel if we had somebody like Segal Chadda's AG or Joey Gilbert?
I'm sorry, I'm not sure that this is pertinent to the
Well, I'm
policy of the
curious-
bill.
Well, because she wants to move it under the AGs, correct? So my question is that smart if we end up in a situation like that?
Thank you for the question, Senator Neal, for the record. So historically in this building, I've always looked at the political changes and whether or not the political change of moving a policy would that somehow change the dynamic. That I believe that placing it under the AG and the fact that the NRS and the legislature is still in play, right? The NRS is still active. Whether or not the AG gets to appoint the administrator and then appoint the commission does not alleviate the legislature from being able to come in and also question the AG if they fall outside of the bounds of the statutes that we actually create. So whether or not it is Elmo, AG Ford, or a future human, we still have the right as a legislature to not only call in related to their budget we also have the right to go in and enforce any violation that is related to Nevada revised statutes. And so this argument that, it should be under Dieter and remain under Dieter, as if that somehow is this unsuccessful, they're keeping it there would maintain the status quo. I feel like there might be more of an issue of, is there a more effective outcome if it actually is under the AG? Will there be a greater enforcement of the existing law if it is under an attorney general? And I think the answer is yes, because they wanted to create an Office of Civil Rights, try to stand it up before AG Ford's exit and whoever the new person is. Why? Because our political environment currently, civil rights is under attack. It is directly under attack. And in my world, where I have a majority minority community, and it impacts everyone, because even under NERC right now, we are protecting the rights of pregnant women in a workplace. That is currently in law. And if we want any kind of real protections and accountability, we need to be thinking about, what does this look like? And based on what I see, there are more political emotions about this legislation than the policy of this legislation. And that political conversation needs to be removed, because what is really going on is you don't like the person who it would fall under. You're not considering what 2026 is going to deliver. You don't want to give a win to somebody who's running for potential future office. That's not my concern. I didn't bring this bill to give AG Ford a win. What I did was, I have been on a journey for 14 years to try to figure out how to strengthen the Nevada Equal Rights Commission so that citizens feel that their complaint will be heard, it will be vetted, that folks will be held accountable regardless if it's a corporation or other, under the law. And that was my public policy goal. And I support and have relationships with the people who are in opposition to this. But to keep saying, oh, I thought this was new law, and I'm like, well, it's not. It's, if you never read 613 or 118, it's current law. And maybe seeing it all in blue scared folks, because they were like, wow, we've really covered the gamut. And I'm like, well, I'm glad we have. I'm glad we've protected pregnant workers. I'm glad we've installed the 1964 Civil Rights Act. I'm glad that we've protected the Crown Act. I'm glad that we have protected employers from placing false information in an employee's file and then writing them up on that false complaint and then saying, I'm going to demote you. I'm glad we have that in law. But those have been consistent fights for the past 14 years to move that legislation. Even when I moved the Crown Act in 21, there was a question of, are we still having hair discrimination? Absolutely, we are. Over braids, over knots, over dreads. Yes, we are. When I tried to move the policy that actually was going to make sure that cannabis off work was going to be applied, I had opposition, hours worth of opposition. And it passed. But you know what ended up happening? They stripped it out in a court. And so those are real considerations that I wanted to put into statute that I have been on a journey to do, and a journey to make sure that the civil rights of the people in Nevada are protected: race, gender, disability, veteran, creed.
Thank you, committee. Are there any other questions? Seeing none, thank you for the presentation. We will now move on to testimony on the bill. Testimony can be provided in person in Carson City, via video conference in Las Vegas, or over the phone, and further instructions for providing testimony can be found on the agenda. We will begin with testimony in support of Senate Bill 160 here in Carson City. Please go ahead when you are ready.
Marco Rauda, M-A-R-C-O, R-A-U-D-A, representing the Arriba Las Vegas Worker Center, and we are in support. Thank you.
Thank you. Seeing no one else in Carson City stepping up to the table, we will move to Las Vegas. Not seeing anyone in Las Vegas. AVH, is there anyone on the line in support of Senate Bill 160?
To provide testimony in support of Senate Bill 160, please press star 9 to take your place in the queue. Again, please press star 9. Chair, we have no callers wishing to provide testimony in support.
Thank you. We will now move on to testimony in opposition of Senate Bill 160. In Carson City, please begin when you're ready.
Thank you, Chair Considine and committee members. Misty Grimmer, Grimmer, representing the Nevada Resort Association. Senator Neal's absolutely correct. We have been doing this dance, I would say, for many years. And we absolutely respect her passion and integrity for trying to strengthen the civil rights protections in the state of Nevada and strengthen the office of NERC. We do, however, feel that with SB 160, that even though it is just a transition of language from one chapter to another, the resources that are available and the types of enforcement and investigation that's available in the AG's office would create a imbalanced situation that would disadvantage employers. So we do think that these statutes should remain in NERC. The statutes in NERC, as Senator Neal has testified, have been developed over many, many sessions, and there's a structure in place that we believe works appropriately. If the legislature would like to do something, it is true that NERC probably could use some more resources. Some investigations do take far too long to accomplish, which disadvantages both the employer and the employee in the situations of those investigations. But at this time, we do feel like moving it over to the AG's office would not be the responsible method for addressing that. Thank you.
Good morning, Chair Considine, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber. Want to echo the comments that my colleague, Ms. Grimmer, just made. We are also in opposition, unfortunately, to SB 160, but are very appreciative of Senator Neal's efforts and passion for civil rights in the state. It is also our belief that this move would create less consistency in the execution of civil rights matters just by way of the changing of the guard right every 4 years within that office. Thank you so much.
Thank you. Seeing no one else here in Carson City stepping up to the table to oppose, we will move to Las Vegas. I don't see anyone in Las Vegas in opposition of SB 160. So AVH, we're back to you. Is there anyone on the line in opposition of Senate Bill 160?
To testify in opposition of Senate Bill 160, please press star 9 to take your place in the queue. Again, press star 9.
Good morning, Chair and members of the committee. Thank you for letting me speak. My name is Kimberly Fergus, Fergus. As I testified in the Senate, I'm going to testify again here in the Assembly for you. I rise in firm opposition of Senate Bill 160. Let's be honest, this bill isn't about strengthening civil rights. It's about embedding DEI ideology into law by forcing identity-based criteria into government appointments and complaint processes. Under Section 8, members of the Equal Rights Commission must be appointed based on demographic traits, race, gender, identity, sexual orientation, not qualifications. That's not equality, it's preferential treatment, and it opens the door to ideology enforcement over merit. This bill also includes a physical note with a state impact, but provides no detailed cost. You're moving an entire commission to the Attorney General's office, expanding volunteer attorney programs, mandating paralegal training, and extending House complaints timelines from Section 21, all with a clear plan to fund or manage it. That's irresponsible government. I don't see color, gender, or sexual preferences when hiring or judging others, and I don't think the state should either. Personal traits don't entitle you to more rights than anyone else. What matters is your ability to do the job. SB 160 prioritizes identity over integrity, perception over performance, and DEI over process. And switching this to the Attorney General's office is just political theater. That's not civil rights. Please, I respectfully urge you to vote no on SB 160. Thank you.
And thank you, Chair Considine and members of the committee. My name is Emily Osterberg, calling on behalf of the Henderson Chamber of Commerce and our over 2,000 members, most of which are small businesses, to express their opposition to SB 160. While we appreciate the intent to strengthen the Nevada Equal Rights Commission, we do have concerns that this shift could potentially politicize a body that should remain independent and nonpartisan. So for these reasons, we are opposed. But thank you to Senator Neal, because we do understand the desire to strengthen this body. So thank you.
If you recently joined the call and would like to testify in opposition of Senate Bill 160, please press star 9 to take your place in the queue.
Good morning, Madam Chair, members of the committee. Stephen Cohen for the record. Rising also in opposition to the bill with a training element for staff. I would switch either to neutral or support. I'm more than happy to work with sponsor on such an amendment. Thank you, AU.
Chair, we have no additional callers in opposition.
Thank you. We will then move on to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral on Senate Bill 160? Seeing no one approach, still seeing no one in Las Vegas. AVH, we will go back to you for testimony in neutral on Senate Bill 160.
If you would like to testify in neutral for Senate Bill 160, please press star 9 to take your place in the queue.
Good morning, members of the Assembly Committee on Government Affairs. My name is Teresa Benitez Thompson, Chief of Staff for Attorney General Ford, calling in neutral. If the committee decides to pass this policy, then the Office of Attorney General sees no issue with taking on the obligation of the Nevada Equal Rights Commission and moving this section under our chapter of NRS 228.
Chair, we have no additional callers in neutral.
Thank you. Would the presenter like to come up to make any final remarks? Please begin when you're ready.
Senator Neal, for the record, I'd like to thank Assembly Government Affairs for holding a hearing on SB 160. I'm more frustrated than anything else, but Section 8 is existing law. It has always had the criteria to have various members on the commission in order to decide what would be a fair viewpoint and diverse thought in order to examine issues that may become before the commission. And so I think rightfully so that diversity should remain, because not all people think the same, not all experiences are equal, nor do they have the same viewpoint or outcome. So a disabled person who may be discriminated against has a different lens of the law versus someone who might be African American, Latino, Asian, or that is actually experiencing some gender discrimination as well. And so with that, I thank you guys for hearing this bill. It's within your wisdom to decide what you want to do with it. I've had the fight. I'll continue to fight regardless if SB 160 moves out of this building. And if I'm blessed to return back to the building in 27, then I'm sure I'll have another piece of civil rights legislation. Thank you.
Thank you, and I will now close the hearing on Senate Bill 160, and we will take a 5-minute recess. Okay, thank you. We are now back from recess. And I do want to make a quick statement. In accordance with Rule 57-4 of the Assembly Standing Rules, Speaker Yeager has provided approval to take final action on the bills heard today within 24 hours of their hearing. And with that, we will now open the work session. We will first take actions on the items the committee heard today, and we will start with Senate Bill 39. Members, are there any questions? Seeing none, I will now entertain a motion to do pass Senate Bill 39.
Second.
I have the first from Vice Chair Nguyen and a second from Assembly Member Carter. Is there any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed say nay. Motion carries unanimously, and I will assign the floor statement to Assembly Member Gurr. Next, we will move on to Senate Bill 160. Members, are there any questions? Seeing no questions, I will now entertain a motion to do pass Senate Bill 160.
Second.
I have a first from Vice Chair Nguyen and a second from Assembly Member Hunt. Is there any discussion on the motion? All those in favor say aye.
Aye.
Any opposed say nay. Please raise your hands. I have Assembly Members Kasama, Edgeworth, Gallant, DeLong, and Gurr. Motion passes, motion carries, and I will take that floor statement. We will then move on to Senate Bill 12, and I will turn this over to our policy analyst, Alex Drozdoff.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. As nonpartisan legislative staff, I can neither support nor oppose any measure before the committee. The next bill in work session is Senate Bill 12, which revises provisions relating to the Office of the Chief Information Officer within the Office of the Governor. The committee heard this measure yesterday. Senate Bill 12 renames the Office of the Chief Information Officer as the Governor's Technology Office, defining its structure, powers, and duties. It replaces the Director of the Department of Administration on the Information Technology Advisory Board with the Chief Information Officer. Additionally, it updates the Deputy Chief of the Office of Information Security's classification and shifts certain responsibilities for investigating and reporting state agency or elected official information system breaches from the Chief to the Deputy. There are no amendments. Thank you, Chair.
Thank you. Members, are there any questions? I will now entertain a motion to do pass Senate Bill 12. I had a first from Vice Chair Nguyen and a second from Assembly Member DeLong. Is there any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed say nay. Motion carries unanimously, and I will assign the floor statement to Assembly Member DeLong.
Thanks, Chair.
And Ms. Drozdoff, please summarize the next bill on the work session.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst. The next bill in work session is Senate Bill 240 in its second reprint, which revises provisions relating to state business licenses. The committee also heard this measure yesterday. Senate Bill 240 reduces the fee for the issuance of a state business license for certain businesses which employ not more than 50 full-time or part-time employees from $200 to $100. There are no amendments. Thank you, Chair.
Thank you. Members, are there any questions? Seeing no questions, I will entertain a motion to do pass SB 240. I have the first from Assembly Member Hunt and the second from Assembly Member Karras. Is there any discussion on the motion? All those in favor say aye.
Aye.
Any opposed say nay. Motion carries unanimously, and I will assign the floor statement to Assembly Member Hunt. And I will turn this back over to our policy analyst, Alex Drozdoff.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst. The last bill on work session is Senate Bill 373 in its first reprint, which establishes requirements relating to multi-jurisdictional business licenses. The committee heard this measure yesterday as well. Senate Bill 373 requires the establishment of multi-jurisdictional business licenses in Clark County by the Board of County Commissioners and each governing body of an incorporated city. The bill further requires these entities to cooperate with each other to establish such a license for any specified category of business and to consider factors relating to the similarity of any existing requirements for businesses. Lastly, the bill requires each board and governing body to establish by ordinance a system for issuing the multi-jurisdictional business license, including a revenue-sharing structure for participating jurisdictions, and to integrate license applications with the state business portal. There are no amendments. Thank you, Chair.
Thank you. Members, are there any questions? Seeing none, I will now entertain a motion to do pass SB 373. I have a first from Assembly Member Flanagan and a second from Assembly Member De Silva. Sorry. Is there any discussion on the motion? Seeing no discussion on the motion, all those in favor say aye. Aye. Any opposed say nay. Motion carries unanimously, and I will assign the floor statement to Assembly Member Goulding. And with that, I will close the work session. We will now move to public comment. Public comment is not an opportunity to rehear a bill, and we ask that you please keep your public comment to topics within the jurisdiction of this committee. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. For telephonically, dial 669-900-6833. When prompted to provide the meeting ID, enter 852-6684-1756 and press pound when prompted for a participant ID. Each person will have 2 minutes to provide testimony. Please remember to clearly state and spell your name for the record. Is there any public comment here in Carson City today? Seeing no one approach, is there any public comment in Las Vegas? I'm still not seeing anyone in Las Vegas, so AVH will go to you. Is there anyone on the line for public comment today?
Thank you, Chair. The public line is open and working. We have no callers at this time.
Thank you. Members, please keep an eye on the committee agendas moving forward. If more business comes before this committee, we will be happy to be back and carry out the remainder of our work. That concludes our meeting for today. The meeting is adjourned.